Well, thanks everyone for joining us. I think today we're very lucky in that. Are you back, John? We're very lucky in that we've got an international panel from across the US and the UK, and we're going to talk about a lot of the cross-border issues that are coming up on data protection claims. John and Katrina are going to talk about the US perspective, perhaps a more advanced regime for class actions than we have here in the UK, which we'll discuss, give a little bit of the evolution of the landscape over there before Kenny and I move on to dealing with what's happening in Europe and specifically England in terms of the hot topics, before covering a little bit about misuse of data as well as data breaches, and then ending, I think, with a look at the future if we have time. With that introduction, I think I can hear John back with us. No, maybe not. Katrina, are you happy to open up with talking about the landscape of data protection claims as it stands in the US?
Absolutely. I can talk on that topic for hours, so I think we'll be all right. John can pipe up when he's ready. Oh, I thought I just heard him. John? Okay, maybe not. So data breach litigation in the United States, I think, started gaining some traction among the most highly publicized breaches. I think Target is probably the most well publicized because it involved so many people and it was national across the United States in scope. As a result of that occurring in 2014, I think most of you well know that there were many breaches that happened in the wake of Target, and sort of this law started developing in this area. I think the initial attacks on the defense side focused heavily on Article 3 standing in federal court. And for those of you who might not know what that is, in order to bring a claim in a federal court in the United States, you have to show that the plaintiff suffered some sort of particularized injury. And defense was focusing heavily on showing that there was no injury, because a lot of times in a data breach case, a person will receive a notification of the breach, but that person would not have actually, if their information was just exposed but not misused, that person arguably did not have a claim that had materialized at the point of them being able to open the courthouse door and file a lawsuit. So early on, I think a big focal point was this Article 3 standing concept, and whether a plaintiff could actually come to court and make out a claim when there was no, they call it concrete and particularized injury alleged. As breaches became more publicized and there were more of them, I think in the wake of Target, there was several large ones, including Home Depot, and more recently, I think Equifax was a very well publicized one. I think the circuits here were starting to recognize that even though a person's information may not have been misused, or they may not have had evidence of the actual misuse, that a data breach could still give rise to an actionable claim. If you think about it, when there's an admitted exposure and a potential for the data to be misused, a very smart criminal is not going to misuse it right away for fear of being traced or the misconduct being traced back to them. So if you think about it logically, a lot of the injuries won't happen right away and will happen in the future. And in order to be vigilant, people need to monitor their credit and monitor their reports, their accounts, to make sure that the information is not being misused and won't be misused in the future. And so is that a sufficient harm in order to open the courthouse door? And that was the question that courts were really grappling with. The tide really started turning on that in the last few years. And I think one of the trailblazing circuits is actually the Seventh Circuit, among others, but the Seventh Circuit has developed some pretty good law on this point. The Seventh Circuit, for those of you who don't know, encompasses the Chicago area where I practice. So I'm gonna shamelessly plug the courts here in my home. But they developed some really good law on the standing issue. One case was against Neiman Marcus, and then another against P.F. Chang's. That basically shows that, or stands for the proposition that a consumer need not have actually suffered a loss in order to be able to bring a claim. So it seems as though the law has developed in a positive direction for us plaintiffs, enabling us to bring these claims. And, as a result of that, you've probably seen a lot of things out there about some notable settlements that have happened and things like that. One hot issue or key issue that we'll probably see in the future is the concept of damages and how damages are going to be shown, if possible, on a class-wide basis in a class action. So there is a distinction between the initial inquiry of whether someone has standing to bring a lawsuit and whether they've suffered an injury pursuant to Article 3 of the United States Constitution, which is a threshold inquiry. Later on, however, at the class certification stage, courts will consider what damages were suffered among the individual members of the class and how those damages may or may not be individualized or susceptible to class treatment. And I think by virtue of the fact that the law is still in its infancy and is just developing, there aren't too many published or reported cases on what happens in terms of damages modeling and when it's contested, whether or not someone can show that everyone in the class suffered the same amount of damages. Certainly, if people are monitoring their accounts, that's time spent, and therefore that time spent should be compensable, and you would think it would be compensable for all members across the class. Certainly, there are people who suffered, specific out-of-pocket losses, depending on the harm that was suffered. And normally, on the plaintiff's perspective, would be that that does not defeat class treatment. But we just haven't seen how that plays out as of right now, because most of the cases are the most publicized that have survived this Article 3 standing issue have settled. So that's just sort of, one to keep your eyes out for is how economic damages modeling would work, whether it would survive on a contested basis when defendants mount a challenge, and what will happen in the future.
So it sounds interesting. There hasn't yet been a decision on what level of damages essentially would be available to those plaintiffs in those type of action, and whether that would be uniform or not, or would it always have to be uniform to maintain the commonality of the class?
Well, the general rule of thumb is that so-called individualized issues won't defeat class certification, and it's sort of a fuzzy concept because the lines are not always clear between individual issues relating to calculation of damages versus so-called individual issues of causation of damages. So in any other case, in a typical case, whereby
you've muted yourself, Katrina, or some fault of technology has.
Somebody muted me.
You're
Apparently back. They didn't like what I had to say.
You've been censored.
I thought it was kind of exciting, but anyway, the general rule of thumb is when individualized, when damages are susceptible to mathematical calculation or formulaic calculation, the question is more one of calculation and not individualized inquiries as to the damages, if that makes any sense. A defendant will normally portray someone's damages as individualized, where they can point to some sort of causation issue and tie it together in order to survive the general rule that damages that are calculable are susceptible to class treatment. So, for example, in a data breach case, on the plaintiff side, we'll say, well, everybody had to spend time monitoring their accounts, and credit monitoring is a class damage that everyone may have suffered. And depending on the amount of time spent, an economist can ascribe a number or a numerical value to the time spent. And therefore, on the plaintiff side, we will say, well, hey, these damages are susceptible to calculation. There's a minimum baseline damage that everyone has suffered because they've spent time monitoring their accounts. And then if there are, other damages that someone can claim based on their circumstances because they were, they had actual out-of-pocket loss or whatever, those people can, on the plaintiff, we would argue, introduce proof of their individualized damages in addition to the baseline. But because of the baseline, the so-called individualized issues don't overwhelm the class, and therefore that would be susceptible to class treatment. On the flip side of that, a defendant would say, oh, no, there are no individualized baseline damages. Everybody spent different varying amounts of time monitoring for their reports. Some people had actual fraud, some people had no actual fraud. This person spent money on identity theft protection, another person didn't, and so they'll argue that the claims are not susceptible to class treatment for those reasons. But as I said, there's no real guidance from the courts yet on whether an economic damages model would be susceptible to class treatment or would be accepted in cases, and so that remains to be seen, and we'll watch for developments on that.
I think the cases you've mentioned there, such as Target, they're data breach cases where there's been a loss of data into the ether from some of these big businesses, aren't they? What about data misuse cases? Are you seeing those in the States?
We are seeing a ton of data misuse cases, and actually, let me just draw a distinction because I think we refer to them as data misuse cases. There are causes of action that are available to a plaintiff. Short of actual misuse of the data, there are actually causes of action that are available on the collection of the data itself, in recognition legislatively that the data is so sensitive and so subject to misuse that just the mere collection alone can give rise to a cause of action. And so there are various statutory mechanisms that are currently available to plaintiffs. And the type of data involved can be depending on the type of data involved. And there's a lot of different statutory schemes that relate to different types of data. One example that comes up to mind, which is actually a federal law, and thus the cause of action is available to anyone in the United States, is a statute known as the Video Privacy Protection Act, the VPPA, which you may or may not have heard of. But essentially, the statute came out decades ago, before the internet was a thing, and it essentially would regulate videotape service providers from disclosing someone's video watching or renting history. So how this is relevant now is that so much video happens online and through so many apps. You see TikTok is an example of people creating videos and posting them online or on the app. Does someone have a cause of action for a collection and or a disclosure of what somebody is watching online? through an app. So there's a federal cause of action available for that, and that's just one avenue of data collection that can be actionable in a litigation in the United States.
Yeah, Katrina, if I could just add, hopefully you can hear me well.
Hi, John.
I don't see me. Sorry, the technical difficulties. So one of the cases that we're litigating that I think has some interest for practitioners in the UK and the EU is the Google incognito case, where the incognito function allows individuals to allegedly surf through the net without detection. We have a case pending in U.S. District Court in San Jose, California, against Google, alleging violations of the privacy laws in California and in various states for the way in which, despite what Google represents to consumers, we allege, monitor and track people as they surf the web. So that's probably one of the most significant data misuse cases now being litigated against one of the largest data aggregators that all of us use for free, not really. So again, you're seeing more and more cases. We have cases against other types of apps like weather.com, which is a free service in the US, but they track your location and they sell that location. So this is a continuing area in the privacy world in the US. One of the things I might add to just the damage model, and I think we talked about this in our pre-session, is the concept of nominal damages, which we borrow from common law. And it's a concept that for every wrong, there's a remedy. And if you're unable to articulate the way in which anyone can be harmed from a privacy violation, typically a data breach, then the concept of nominal damages should be awarded, whether it be $1, a pound, or some other amount. But when you're talking about some of the numbers of individuals who are affected in data breaches like Capital One, which almost 100 million Americans lost certain types of PII, personal identification information, a $1 or $10 award by a jury would be significant. And it's a common injury suffered by all, even if you cannot articulate an individual injury. And then, of course, the other one that we're pushing is the concept of monitoring the risk of identity theft, which has arisen because of the exfiltration of this data by cybercriminal. In the United States, we have this concept called medical monitoring, where if a person is exposed to a hazardous condition and they have not yet manifested an injury, then medical monitoring can be awarded by the court to the class, so that individuals can go through a monitoring to ensure that if and when they manifest the disease, they can get the appropriate treatment. So true, when information is taken, it's taken to monetize, to steal someone's identity. So we have the concept in the United States of identity theft protection or credit monitoring. So that is a risk model that we believe that we can apply on a class-wide basis. It costs about $200 a year US to provide that service. And again, when you begin to think about lifetime identity theft protection for 100 million people, you're in the tens of billions of dollars pretty quickly. So those are some of the things that we're now pushing. We've not yet succeeded on that, but we're in a developing area in the U.S.
And John and Katrina, do the statutory regimes, do the rights that are given to data subjects across the states vary widely, or is there a common level of protection?
Well, John, you want to answer that, or do you want me to?
Yes, so there is no federal law that provides for a statutory remedy for data breach. There are some. The Driver Protection Privacy Act, which provides liquidated damages for consumers where their driver's license information is obtained from a Department of Motor Vehicle and misuse. There are 14 enumerated exceptions, but there just are not that many. Katrina,
Yeah.
I'll let you talk about BIPA, and of course we now have the California Privacy Protection Act, which is beginning to be used for California consumers who are the subject of data breaches in their state or in other parts of the country. So, Katrina, I think the BIPA statute is cutting edge.
Yeah. So, as John said, there's no comprehensive federal guideline on this. As I mentioned, the Video Privacy Protection Act is a federal statute, and so it does give rise to a cause of action, but it's limited to the video stuff. State by state, I think there's growing recognition that biometric privacy and biometric data is a concern. And the Illinois, they call it the BIPA statute. It's the Biometric Information Protection Act. It, as I said earlier, actually does not require a data breach. It regulates the collection of the information itself in recognition that the data is so sensitive that it need not be breached in order for someone to have a cause of action for the taking of it. The Illinois law is limited to biometric information. So, and there's enumerated categories, but generally whenever facial recognition is involved, the creation of a facial template or the use of a voice print, thumbprint, any fingerprint would give rise, the collection of that data would give rise to a violation if the data was being taken and not consented to. The California statute, I believe, came as a response or as a corollary to the Illinois law. It's a bit more limited. It does require that the information be breached before a plaintiff has a cause of action. So it's a little more limited in that respect. But the statute just came into being, the California law, not too long ago. I think it just went into effect this past January. And some cases have been brought, but the issue hasn't been litigated. But I suspect that we'll see people filing cases and trying to broadly construe the concept of what is a breach, and maybe trying to shoehorn it into just disclosures in general, because a lot of times, just like John had mentioned, what Google is doing is, the information is being taken and shared in various ways. So whether or not a disclosure to a third party may constitute a breach and thus a violation of the California law, I think remains to be seen. And, we'll see what happens in that area.
Yeah, there are certain elements of that statute that have to be met. Not every data breach necessarily meets that. Certain information must have been taken. The company must not have, for its size, had a certain level of best practices in connection with the safeguard of that information. I've litigated that in 3 cases. I've settled 2 of them with the monetary relief provided by the statute, which is a scale. And I've abandoned another claim in the resolution of another class case because the breach in that case involving payment cards occurred prior to the enactment of the statute. We had an argument, but didn't think it would succeed. So to Katrina's point, there is no decisional authority which has construed that statute in connection with the data breach that I'm aware of. Our cases to date, which we filed, have all been resolved with little discovery because a company understands the repercussions of continued litigation when they would rather put money towards resolution, maintaining reputational or preventing reputational damage, and just resolving those claims. But it is a good statute, at least to have as a hammer, so to speak, to be able to seek uniform redress for affected consumers.
You want to tell us about Europe, Simon and Kenny?
Sure. Will I kick off there? Great to be here, or virtually, so to speak. I was going to say a few words about group data protection claims until the Lloyd and Google claim, which I think Simon will speak a little bit about, although I may mention damages in that context as well, and really kind of how these claims have previously been brought and their distinguishing features. And I'm going to do that by reference to a number of themes. And so first of all, and most notably, the claims to date, the very high profile large data protection claims have been brought using opt-in mechanisms, predominantly our group litigation order mechanism, which has got a fairly straightforward certification, equivalent to a certification requirement, which is that those claims must give rise to common or related issues of fact or law. And of course, given that these are opt-in mechanisms, that creates a significant practical issue for the claimant law firms and claimant management companies who will be advertising the claims on a no-win, no-fee basis, and also having purchased adverse costs cover, given that the adverse costs can be quite significant in the UK. And that, of course, encourages participation and take-up amongst putative members of the group. But having said that, take-up rates are relatively low. So one of our there's a number of high-profile data breach claims have been brought or are still ongoing, one of which was the Morrison's claim, which involved a leak of payroll data for around about 100,000 employees. And that claim had a take-up rate of about 5.5%. These can still obviously be large claims, but 5.5%, it shows that it could be a lot worse, shall we say, under an opt-out mechanism. The second theme is that up until now, these have been really follow-on claims, particularly the large ones, either following on from a formal finding of infringement or anticipation of a formal finding of infringement by our regulator, the ICO. And of course, the regulatory finding helps in a number of factors for the claimant law firm. But a very significant factor is the pull factor for putative class members. There's obviously a persuasive element to the fact that there has been a regulatory finding of infringement and will make it more likely that people will participate. And third, these claims to date really have predominantly been for data breaches. We haven't really seen large-scale claims for alleged misuse of data under opt-in mechanisms. We've touched on that from the US perspective, and I'm sure we'll touch on it again later. The other area where we've seen progressive development prior to and then delving into Lloyd and Google is in relation to the damages that are recoverable and the categories of loss that qualify for financial redress and compensation to members of a class. So obviously the most obvious category is pecuniary and financial losses, but they would usually only arise where credit card data has been lost and spent on, and only for certain types of data breaches or subsets of persons within a data breach. The second category, which has been around for a while, is claims solely for distress. But those will be a relatively individualized situation. And going back to the Data Protection Act of '98, which is the statute under which the Lloyd and Google claim is brought, the precise literal wording of that statute suggested that damages for distress were only available if the claimant had also suffered other damage, perhaps pecuniary or material damages. But the English Court of Appeal decision in Vidal Hall, which actually arises from the same underlying facts as Lloyd and Google, confirmed that damages for distress were permissible even if the claimant hadn't otherwise suffered, for example, pecuniary losses. And then with the GDPR, Article 82 of the GDPR confirms that claimants can recover compensation for material and non-material damages. So that's the position on distress. But third, and this is the new category of losses, which is in Lloyd and Google, the Court of Appeal confirmed that there are circumstances in which a data subject may be able to recover damages for the loss of control of his or her data, and that's an entirely new development. And Simon, you mentioned earlier on that we don't have a ruling, of course, on what the range of damages, what kind of quantum you would expect to see for loss of control on an individualized basis, or indeed even how the court will go around quantifying them. There was a discussion in the Court of Appeal decision about looking at the user damage test and what is the value to the defendant, but that was all obiter and didn't make a finding. So that's all a matter for trial. The Court of Appeal did observe that individualized losses would have to be for the lowest common denominator when the representative action mechanism is used, but that they won't be nothing. So that's all a matter for a court of trial. But of course, with classes of this size that you get under the opt-in under the opt-out mechanisms, the fact that individualized damages are potentially very low is not of much comfort to defendants, and that's the real game changer. But that was just some kind of background and some of the progression we've seen in the UK. But I'll maybe hand over to you, Simon, if you want to say a little bit more about Lloyd and Google.
Yeah, sure. I mean, really, Lloyd and Google is the threshold moment here in England and Wales at the moment in terms of where we go with opt-out class actions. At least, as you've said, there's an issue about damages in that case, but it feeds into the key question of whether it's possible to bring these claims as opt-out claims, essentially, in England, because of the way that our representative action under 19.6, our only real opt-out procedure outside of the competition space, is set up. And that means that the claimants in those classes all have to have the same interest in the claim. And as Kenny was saying, there was a huge debate in both the first instance court before Justice Warby and then later in the Court of Appeal about how these claimants, who there are I think 4.4 million claimants in the Lloyd and Google claim, how they could all suffer the same loss or have the same claim in circumstances where some of those data subjects will have been deeply distressed by the fact that this had happened, by the fact that their data had been taken. Others perhaps wouldn't have cared so much, or may even have been encouraging of the fact that they were able to see advertisements that were more targeted to them. So there's a broad range of individual issues that could potentially come up, but the court decided that it was possible for the individual circumstances of all those claimants to be disavowed, boiling the claim down essentially to a value of a loss of data for the claimants. And that was by analogy to a case called Galati, which was actually a misuse of private information claim. But the court came to the conclusion that the misuse of private information rights and the rights under the Data Protection Act, rather than the GDPR at that point, both had as their foundation Article 8, and they needed protecting under English law, under EU law. And so the way that the class had been crafted, meaning that individual circumstances were disavowed, each claimant had lost the same thing, which was the loss of their ability to control the use of their data. And I think that's a common theme in the US now as well. And that had a value. There was lots of somewhat philosophical debate, and I think there will continue to be philosophical debate about how you exactly determine that. As Kenny said, there was a question about whether it could be user damages. So essentially, we have a principle here where you're able to extract a negotiating fee or a negotiated fee for the use of your data from a counterparty. And it's difficult to see circumstances in reality where that happens. The court at first instance said, but the Court of Appeal disagreed with that and said that's an arguable basis for damages, although it didn't form part of the judgment. So at the moment in England, we're in a a slightly unhappy place because both our procedural mechanism for opt-out claims at least, and our damages position are unknown until such time as the Court of Appeal's decision is approved or otherwise in the Supreme Court, and that I think will be in the spring of 2021. Once that lands, we'll have much more certainty around where we are in terms of opt-out actions, at least in England and Wales.
Maybe worth just briefly mentioning as well one of the other major things that's happening in the UK just now in the field of potential group data protection litigation, which is currently ongoing consultation, which I've been surprised by how it is public, but it's not had as much publicity as it perhaps could have had given the potential consequences. The consultation is being run by the Department for Digital Culture, Media and Sport, and it's reviewing Section 189 of our Data Protection Act, which is the representative action mechanism, and the DPA actually mandates this consultation. It mandates a review within 30 months from when the DPA came into force, and so that is expiring shortly. And the consultation is covering a few topics, including the right of representative bodies to make a complaint to the ICO on behalf of others, but most significantly, it also is addressing or considering whether to introduce the power for a non-profit making bodies to bring civil claims for damages on behalf of individuals without those individuals' consent. So, classic automatic aggregation. Unclear actually whether or not they have the right to opt out, but it's a classic opt-out system and dragging people in. The consultation is, the governmental department is reporting to Parliament on the 25th of November. So that is just next Wednesday. So it's all very current. And we should at that stage have a better view of what the government is going to do here. And it's kind of worth, also what will they do? They didn't actually say what sort of regime they would introduce if they do actually move to introduce it. So will it be modelled on our antitrust competition mechanism that was introduced in 2015 by statute, which has a degree of checks and balances, because the only factor under 19.6 is whether class members and the representative have the same interest. Whereas under our competition law, they look at the suitability, they look at the representative, there's ban contingency fees if it's brought in an opt-out basis. So everything's on the table. It is possible that both mechanisms become available if the Supreme Court upholds Google and the government introduces this. But there's a lot of flux in moment right now. And naturally, if both mechanisms become available, then no doubt claimant law firms will look at whichever procedure best suits their circumstances of the case, even if the representative action narrow same interest test is hard to achieve. And there may be some circumstances where they were to use the other mechanism. So there is a lot going on right now.
Absolutely. I think where we stand, if you take the Court of Appeal's decision, it was a real endorsement of the use of the representative action for claims like this. Voss was very clear that he didn't think that it was inappropriate for claims on a mass scale to be brought through the representative action regime, and that the pro forma, the uniform level of damage, which was unusual in terms of its approach back in the at the time when it was brought, he thought that was a perfectly acceptable way of calling companies like Google to account if the breaches that that have been alleged can be proven. So there was sort of a ringing endorsement of the procedure in the Court of Appeal. It will be interesting to see whether that sentiment is echoed in the Supreme Court, and if it is, whether that affects the way that the government decides to deal with the consultation or not. I'm assuming that they will actually report on I think it's the 25th, isn't it, of November. But who knows whether that process will be dragged out later into next year, given everything else that's going on.
Yeah, that's right. I mean, there could well be interaction between the two, and when the government was consulting in 2012 on introducing the statutory mechanism for competition class actions. That was not long after the Court of Appeal in Emerald Supplies had rejected the use of the representative action mechanism, and so therefore the kind of pro-claimant respondents to the government consultation pointed to the non-availability of the representative action mechanism in those sorts of cases, or at least in how that case had been formulated. So yeah, the government may well wait. The timeline for the report is on the 25th, but then no hard timeline beyond that. So they could well wait to see what the Supreme Court does. And is there a lot of attention on Lloyd and Google in the US, Katrina and John? I mean, you know, it seems to me, just taking a step back, that a lot of what happens in the US and a lot of the work that's done is at the certification stage, and you know, achieving your Rule 23 standards, and the economic and evidence and bringing it in that way. Whereas we have this very narrow door, but with a single requirement under representative action mechanisms. I don't know if you've got kind of observations from what's happening in Europe and how you see that from the US perspective.
John? I don't know if he's with us or not. No, I mean, I think, you know, we've been more focused on these threshold standing issues. And I think, as I said earlier, you know, the law is just developing. So, you know, I think we're definitely paying attention to what's going on all over the world and in Europe. But, you know, I think we're definitely paying attention, and we'll see what happens. And, you know, to the extent that you all are able to develop new theories that will once the cases progress to our damages phase, I think it will be helpful.
Yeah, we have very little jurisprudence in this area. We've had 2 cases certified for damages, but having spoken to the lawyers in those cases, they really weren't certain what the court had done. Earlier last year, I had an opportunity to certify a case against Facebook for a data breach involving 40 million users worldwide, 8 in the US, 8 million. And the court certified an injunctive relief class based upon his perceived need, as we articulated it, for improved business practices to ensure that the breach didn't happen again. The judge was not impressed with our relatively little impact that our client, the class representative, had. So the judge declined to certify that case under B3. So we remain, you know, in pretty much the seminal stage of articulating damage concepts in class litigation context.
I think we're coming towards the end, but I've got one more observation, kind of at taking a step back, and from the defendant perspective, and for corporates that are facing new challenges, which is it's going to be a lot more complicated. I mentioned earlier on the kind of linear approach to these cases, historically with the regulator and then a regulatory decision and potentially a damages action. But if opt-out mechanisms become established in this area, we're going to see a much more accentuated rush to the courthouse dynamic. And it's interesting to see claims are being filed with litigation funding backing, even in advance of the Supreme Court hearing in Lloyd and Google, because of the upside, presumably anticipating class carriage fights in a really open field under 19.6, where there's no regime for how those issues will be resolved. So, in-house counsel and DPOs are going to be facing claims coming earlier, and also, opt-in claims will remain, for pecuniary and distress. for opt-out in the UK, we're looking at loss of control damages, but you could have different types of group proceedings, even in one jurisdiction. And that's before you move into the patchwork of Europe, with claims being filed, data protection claims being filed in the Netherlands, and other data protection associations being set up and being authorized to bring claims elsewhere in Europe. So it's data protection officers have been busy over the past couple of years, but it's going to get even busier.
I think that's right, Kenny. And just to follow up on that, your point about the role of the regulator in this, and as you say, a lot of the data breach claims have followed a regulatory enforcement notice or awaiting some sort of enforcement. I think in the misuse space, you're going to increasingly see claims filed before that kind of regulatory action is taken, and it's interesting because I think a lot of these claims are, I think I heard them described as proprietary on one of the other panels, whereby they are claimants and to some extent law firms who understand how a lot of these technology businesses are operating, and they're not necessarily client-facing or consumer-facing businesses. So regulators are not looking at them very closely, and they're not always the entities that people think they're interacting with when they're traversing the internet and carrying out those kind of activities. It's not the front-facing business sometimes that's carrying out these data protection infringements. It's businesses behind that, and to understand that, you need someone who understands technology, and they're not things that are on the front of the FT. These are things that data privacy campaigners and data privacy experts understand, and a lot of them have a technology background. And I think that's driving these claims to a certain extent before regulators have even got involved.
Thank you very much, everyone. Apologies again for slight hiccups at the beginning of the session. And of course, everything will be edited on the recorded version that will be available later on for everyone that wasn't able to make it today, or attendees, but also open to anyone else that wants to share on social media and so forth. I would also like to congratulate Alison Campbell, who managed to win the bottle of champagne courtesy of Accolade. Thank you very much for registering in the first place. And yeah, now that everything is shut on a Friday on lockdown, maybe that's a good present to receive. Thank you, guys. Let's move on to the next session without a break, unfortunately, but I think these guys deserved every extra minute because they were great and they made it work irrespective of all the hiccups. Thank you again, everyone.
Thank you very much.
Thank you.
Thank you.